So let's start off by looking at the issue in context. Why is this issue topical? Well, notwithstanding Brexit, lots of clients still own properties abroad, and often in Europe. And a lot of the countries where they own properties in Europe are civil law jurisdictions, such as France, Spain, or Italy. At this point, I should offer a disclaimer. When I talk about civil law jurisdictions, I'm talking in very general terms. While there are many similarities, not all jurisdictions are the same, evidently. I should also point out I'm not actually legally qualified in any of the jurisdictions other than England, though what I'm saying is based on my experiences of dealing with several of the European civil law jurisdictions and interacting with them and the advisors that are advising on matters over there. Anyway, coming back to our internationally focused clients, this in and of itself is not an earth-shattering revelation that they own properties abroad. Many private client practitioners dealing with clients with international connections will be very well versed in drafting English wills, which take care not to revoke inadvertently any foreign testamentary dispositions, and to ensure that the taxation position is properly regularised. Beyond that, I think most are probably happy with the idea, with the concept that foreign immovable property is subject to the law of the place where the property is situated, the lex situs. That following a death, dealings with that property post-death, for example, transfer of the title of the property to the beneficiaries or a sale, will be by a lawyer, often notary, in that jurisdiction. So I think that covers most of what I have said. I think the key thing really is to try and manage the courts during the process and explain why you're deviating from the standard questions that would ordinarily be answered. One question that we haven't dealt with is what the court would do if the court was asked to renounce a succession, for example, in relation to a foreign succession. So, and there's a case that I've been instructed on recently where the debts in the civil law jurisdiction exceed the assets, and therefore it's not appropriate for the child to accept the succession because they're just going to take on a lot of debts. I think in those situations it should be quite clear that the court will, and I hope that the court will, authorise the person with parental responsibility to renounce succession. However, there will be other cases where it is less clear-cut as to whether succession should be renounced or not. However, I'm not aware of any judicial authority on that, and that is going to be a question for another day.